Miss Kim has a new office.
I'm looking.
Oh, actually, I parked. I'm in a safe place, Your Honor.
I understand we have to do what we have to do sometimes.
Absolutely. I like your office, by the way.
It's probably neater than your real office, I imagine. All right. And let's see, PD Armstrong, McLeod. Let's see, where's the state? No cameras. There we go.
We're here.
Duncan, how are you?
Good, Your Honor.
And Mr. Young. Okay. Well, we will get started. All right. Good afternoon, ladies and gentlemen. My name is Regina Mincy, and we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge. So we are able to handle several matters, including bond, possible arraignment, and consideration of possible plea offers if one has been made by the state at this juncture. Let's see, our reset date is
March the 21st.
All right, our SAP reset date is March 21st. I want to begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube, so govern yourselves accordingly. I want to also remind the defendants on this calendar that you have certain constitutional rights. The first being that you have a right to have representation and counsel with you at this juncture, which most of you know who your attorneys are. You also have the right to remain silent. And remember, anything that you state about the facts, the circumstances, or the occurrences of your case can and will be used against you at a later date. The prosecutors are here, they're listening. So listen to your attorneys and govern yourselves accordingly. All right, deputies, who do we have first?
Position 8, Miss Moon.
Position 8, I can barely hear you. I know you're far away, a little bit.
Miss Moon.
Okay. This is 23 CR 001360F. Diana Moon, charged with 1 count of battery family violence. The offense date is March the 7th, 2023. Pre-trial.
A third arrest. All she got is DUI tonight.
Okay. Yeah. All right. And this is ASG Duncan's case? No?
Yes.
Oh, yes. Okay.
Yes, Your Honor. This is my case. This incident did occur on March 7th, 2023 at 222 Granville Court. The victim in this case is James Bryant. I'm unsure if he is on the line. However, when the time is appropriate, the state would like the court to sound for him. In this instance, the officers responded to that location in reference to a person's screaming call. Upon making it to that location, they met with the victim in this case, Mr. Bryant. He stopped the officers in the parking lot and he let them know that his girlfriend, the defendant, had attacked him after he did not allow her to see his phone, and that she struck him in the face and around his upper body. He indicated that they had been drinking at this occurrence. The officers noted that this victim did have a visible busted bleeding lip and marks around his upper body and face area, consistent with being attacked by the defendant. She then tried to tell officers that he bit her finger. When officers asked how did her finger get by his face, she tried to indicate that she didn't remember how that happened. Based on everything that was told to the officers, they determined that Ms. Moon was the primary aggressor and she was arrested in this incident. We were not able to make contact with Mr. Bryant. Given that this did occur just yesterday, we believe that there has not been a sufficient cooling off period. We do have concern about the risk of reoffense. They do live together and have been living together for some time. We also have some concern about intimidation of this particular witness, given that they are in a romantic relationship. Given that this defendant's entire history is DUI convictions, and this case does involve alcohol as well, the state is going to be requesting a $3,500 surety. No further contact with James Bryan. That's James, common spelling Bryan, Bryan. Stay away from the incident location, already stated on the record. 1 day anger awareness. No alcohol, drugs, and weapons. No further violations of Georgia law, and an ADET. Nothing further from the state. And the court would like, well, the state would like for you to sound for Mr. Bryant when it's appropriate.
All right. Thank you. Mr. James Bryan, are you on the Zoom call? Mr. James Bryan? Nope. All right. I will go ahead with the PD's office. PD
Yes.
Kim?
Yes, Your Honor. Miss Moon is 57 years old, and she was born and raised here in Georgia. Your Honor, my client has a very deep voice, and she was yelling out for help, and it was my client who was asking for help, but the neighbor thought it was Mr. James Bryan because of her deep voice. Your Honor, she was calling for the help because she was attacked by James Bryan, who was drunken at that time. Yes, they have been dating together. However, the place 218 Grayville Court, which is also incident location, that place is in her name solely, so he can move out. So we would like to request for one-time law enforcement officer visit there to verify he moved out, and then my client can move in back to her place. My client has been working here at one place, one dental family dentistry for 40 years. After she graduated from high school and getting science degree, associate degree, she has been working as a dental hygienist for the last 40 years. She has been here. She has a strong ties to the community, and she has her children here. She has 8 years old grandchild. Her sister's here. She's not going anywhere, Your Honor. So we would like to ask for signature on bond. Also, my client has a bruise around her neck because Mr. James Bryan tried to choke her, but police couldn't see that, and she can show it. So I guess we would like to ask for signature on bond for her. Thank you.
And if I may very briefly, Your Honor, it's indicated that this particular defendant did attack Mr. Bryan because she accused him of cheating. And when he walked away, she admitted that she followed him outside. And at that point, she did try to indicate that she was attacked by Mr. Bryan. However, the attack she stated to officers was that he bit her finger. Officers saw no bite marks, but they did see bruises on Mr. Bryan, on his neck and back area, and he had a visible busted lip. And because of that, she was determined to be the primary aggressor. Nothing further from the state.
All right. And again, the parties share this, I think I heard 218 Granville or 222 Granville.
Yes, it's 222 Granville Court. They both lived there together. And I'm sorry, just to add briefly, there were other witnesses who were on the phone with Mr. Bryan at the time because he called them for help, and they heard the entirety of the incident. Nothing further.
All right.
Excuse me, for clarity, is it 22 or is it 218? Because I'm showing 218.
Me too.
I had 222 Granville. I can check if the court would allow me just a moment.
Okay.
I think my client is saying it is 218, right?
Yeah, that's
Yes.
what I'm showing.
Yes.
Okay.
Your Honor, about the witnesses, those are hearsay. We have not heard anything about it. We would like to still request for a signature on bond. My client has bruises around her neck as well.
And as we know, the rules of evidence are not necessarily relevant for these bond proceedings. Nothing further.
All right. I I do also look at the criminal history of the defendant as well, and weighing and considering the Ayala factors. I'm going to order a $4,500 signature bond, and I'm going to order that signature bond through the jail. I'm going to order the 1-day anger awareness course, and I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to order, and because it sounds like Ms. Moon is working, an ADET, and to follow any recommendations if there is an alcohol problem. And that should be it. That will conclude the case.
What is the court's ruling regarding contact, Your Honor?
Oh, I'm sorry. No further contact with James Bryan. And I'm going to order that stay away from the 218 Granville Court. But if Ms. Moon gets a police escort who goes back there with her to determine, as we state, that one-time police escort to get any personal belongings, and he doesn't have any belongings there or has moved out, and officers are pretty good in determining that, then she can stay there. But if he still has belongings there and appears he lives there, then Ms. Moon is to only get her personal items and not stay there. Is that clear, Ms. Moon? Okay.
She already left.
Oh, I'm sorry, you did switch people.
And it
Her
is,
attorney will explain it to her.
Okay.
Sure.
and it is 218. I just wanted to correct my recitation for the record.
Okay, great. All right, 218. All right, that'll conclude this case. Who do we have next, Deputy?
Position 9, Ms. Peck.
This is 23 CR 001361A. Isabel Peck, charged with 1 count of simple battery, family violence. Offense date is 3/7/2023. Pretrial.
First.
Okay. State.
Yes, Your Honor, this incident did occur yesterday at 1410 Huntington Chase in Sandy Springs. The victim in this case is Keith Lewis. We'd like the court to sound for him when the time is appropriate. That's Keith, common spelling Lewis, Lewis. In this incident, officers were dispatched on a domestic call. When they arrived on scene, they met with Mr. Lewis, who was standing outside of the building. He stated to them that the defendant in this case had gotten into a verbal argument with him inside of the apartment, and that he was trying to de-escalate the situation. She continued the verbal argument and followed him and began to strike him with her fist. He stated that he did push her away from him in an attempt to de-escalate the situation, but she continued to strike him. Officers did speak with the defendant on scene at the time, and she admitted to following Mr. Lewis and continuing the argument. She confirmed that she did in fact strike him in the face while outside of the apartment. And she told officers that she struck him in an attempt to grab his attention and to try and finish their argument. And based on what was gathered from the statements made by both parties on the scene, officers concluded that the defendant in this case was the predominant aggressor. we understand that this is the defendant's first arrest. However, we do have some concerns about the risk of reoffense, given that her and the defendant do live at this location together. We don't know the circumstances of the argument, and since it just happened yesterday, we do not believe that there has been a sufficient cooling off period. We did get a chance to speak to the victim. He does not want to prosecute. However, we do have some concerns about intimidation of the witness. As Your Honor knows, the cycles of violence. We just want to make sure that this victim is particularly safe, given that he tried to de-escalate the situation and this defendant continued it by striking him. For those reasons, Your Honor, the state is going to be requesting a $2,500 surety bond, no further contact with Keith Lewis, a stay away from the incident location, 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. And we would like the victim to be sound for.
All right, is Mr. Keith Lewis on the Zoom? I do see a Keith Lewis.
Yes, I'm here.
All right, Mr. Lewis, would you like to address the court?
I'm Keith Lewis.
Yes. Would you like to address the court about this case?
I mean, it was over escalated.
Hold on a second. I have to swear you in if you're gonna, and that was my first question. Would you like to make a statement to the court? Yes or no?
I mean, yes, in a way, yes.
Okay, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, I do.
All right, put your hand down. And what were you going to say?
I was going to say that this whole incident had already gotten escalated, and by the time the police had arrived, everything had already been cooled down. I had gone and gotten cigarettes to come and just relax, and at that point, she had been fine. Like it just got out of hand too fast, and there was nothing I could do after that. I obviously didn't want her to be arrested, and didn't think it was worth her going to jail over this. And I'm not trying to keep her away from home, because this is where all of her stuff is, and this is where she's been for quite a few years with me, and I really care about her. And that's
All
it.
right. Are you in fear of Ms. Peck?
No, not at all.
All right. I'm going to grant,
Your
and
Honor,
again, I'm sorry, what was the state's recommendation again?
the state's recommendation was a $2,500 surety, but I don't think the defense has gotten a chance, and the state also had some follow-up questions.
I'm so sorry.
Oh, that's
Ms.
okay.
McLeod.
My
Go ahead.
client is 26 years old.
Okay.
She is a native of Georgia. She's actually from the Gainesville area, she tells me. She has her parents that she is quite close with. They are in the Gainesville, Georgia area. She has been gainfully employed as a restaurant manager for some time, and she has known the alleged victim, Mr. Lewis, for some time. I think since 2018 at least. I had the opportunity to speak with him, and he assured me that the whole thing just got escalated. He was not the one who called the police. He was just outside. I think someone, may have seen them arguing and called the police, but he was not the one who called the police. He tells me he's not at all in fear of my client, and they have been in a relationship, and that he loves her and he wants her back at the house. I had talked to my client at length. I asked her whether or not this sort of thing happened between them before, and she said absolutely not. So, Your Honor, given the fact that she has absolutely no criminal history, I'd ask the court to give her a signature bond with conditions of no further violent contact with Mr. Lewis, because I believe that would be his preference, and it is my client's preference. Nothing further, Your Honor.
And if I may just have one follow-up question for Mr. Lewis, if that's okay with the court.
Yes.
Mr. Lewis, yesterday on March 7, 2023, did the defendant in this case, Ms. Peck, strike you?
She was like karate chopping me just to get my attention, which is no big deal to me.
But she did strike you, correct?
Yes, ma'am.
Nothing further from the state.
Okay. Originally said Ms. Peck is 26.
Yes, Your Honor.
All right, I'm going to order a $3,500 signature bond through pretrial per judge. I'm going to order a 1-day anger awareness course. And to make sure that there's been ample cooling down, I'm going to order no further contact with Keith Lewis and a stay away from 1410 Huntington Chase. This has just occurred, and from what I've heard, we want to make sure that the victim will be safe and that there will be no other incidents between you. And no drugs, alcohol, or weapons while on bond. And that's going to be the ruling of the court for today.
And the state would just like to place its objection to the signature bonds for the family violence battery cases on the record.
All right, I will. All right, thank you. Good luck to you all.
Thank you.
Mm-hmm.
Position 11, Ms. Smith.
This is 23 CR 001365B. Claire Smith, you're charged with 1 count of battery family violence. The offense date is March the 7th, 2023. Pre-trial.
Yeah, let's see. 2009 ag assault, it was no bill. 2010 battery, pled nolo. 2011 probation violation. 2016 trespass, simple assault. Trespass was amended to disorderly conduct. That was a conviction. 2017 contributing to delinquency of a minor. Cruelty in the first degree. They were no bill. 2017 obstruction, bind over. That's all I got.
All right. And for the state, is it Mr. Jones, ASG Jones?
Yes, Your Honor, that will be me. I'm here under the 3rd Year Practice Act.
Okay.
So, Your Honor, on March the 7th, 2023, officers responded to a dispute call at 2423 Martin Luther King Jr. Drive, where the victim, Mr. Ricardio Bray, and that's spelled R-E-C-A-R-D-I-O, Bray, B-R-A-Y, advised the officers that he came into the home and Ms. Smith began questioning where he had been. He was then asked to leave the residence and began packing his belongings. After seeing the victim pack his belongings, Ms. Smith grabbed a wine bottle and threw it at the victim, making contact with his shoulder, causing a visible bruise. We do not believe that there has been a sufficient cooling off period, Your Honor, as this has just taken place yesterday. The defendant was cited as the primary aggressor. She is a multi-state offender, and we think that there's a high chance of intimidation given their relationship with each other. Therefore, at this time, the state is asking for a $2,500 surety bond, no further contact with the victim, Ricardio Bray, and no drugs, alcohol, or weapons, or no violation of any Georgia laws, Your Honor.
Okay. And for the PD's office, PD Kim?
Yes, Your Honor. Ms. Smith is 48 years old, Your Honor, and she has 5 adult children. One of them just got killed not that long ago. Your Honor, my client is a survivor of domestic violence, and she is currently working at Kroger Distribution Center. She's been working there for the last 2 months, and she really want to keep this job because she does not have any other income sources other than that. And a little bit of food stamps and disability check, which is not enough. She barely pays for the rent. Mr. Ricardo Bray they do not have a relationship. My client denies that they had any relationship. It was him who could come and visit since he was the one who kind of helped her to get that apartment. So she was showing the I guess, courtesy to his fellow friends. They are not living together. It's just that they happen to be together. Indeed, Ricardo Bray has another completely different address where he resides with his uncle, 400 Fairbairn. So that's his address. And my client is the sole leaseholder of 2423 Martin Luther King Jr. And Your Honor, she claims that she was not the primary aggressor. Indeed, right now, Mr. Ricardo Bray was arrested for disorderly conduct and other things. So that way, he is in city jail and he's not here yet. That kind of shows that, you know, it was really hard for the police to determine who was the primary aggressor. It was Ricardo Bray who kicked the door, scared my client to the point that she was still scared of her life. She's very happy with actually the stay away from his place, which is 400 Fairbairn, and also no further contact with him. We would like to request for signature on bond since she has a very, very limited financial means. She's qualified for public defender services, so we will continuously represent her. And we would like to request for signature on bond, or if Your Honor is not inclined to give her signature on bond, maximum $1,000 good bond. Thank you.
Your Honor, if I may, just briefly,
Yeah.
the victim was trying to leave the house, hence why the door was damaged. And by no means does that give the defendant any recourse to throw a wine bottle at him and strike him. I would like to sound for the victim. I'm not for sure if he's on or not, but if we can sound for him as well.
All right. Mr. Ricardo Bray. Ricardo Bray.
I believe he's in a city jail, so he cannot be here. And also, Your Honor, there was no, I read the warrant, it says there was no bottle, there was no glass shattered around any place of the house. He's lying, Your Honor.
Okay.
Your Honor, again, officers did observe a visible bruise to Mr. Bray's shoulder, which is where he said that the defendant threw the bottle.
We deny.
Mm-hmm. All right. I'm going to order a $2,800 surety bond. I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to order no further contact with the victim, Ricardo Bray. I'm going to order a stay away from 2423 Martin Luther King Jr. Drive. And I will allow, does there need to be a one-time escort or not, PD Kim?
Yes.
All right, I will order that.
Yeah.
Huh?
To verify he doesn't reside there.
Okay, and so again, Ms. Smith, when you go back there with the police with you for your escort, they will look through the location to determine whether it appears that the victim, Ricardo Bray, still lives there or not.
He never lived there.
Never did? Okay, well, when you go back.
Situation, Val.
Please, Ms. Smith,
Okay.
please.
No, he doesn't live there.
Okay, so when you go back with your escort, with your law enforcement, they'll determine if there should be no clothes or things of his to make it appear that he lives there. And as long as he doesn't, then you can stay there. If he does and has things there that would make one think a toothbrush, some clothing, and other items that he lives there, then the officer will tell you that you can just get your belongings and go somewhere else.
Okay, so can I ask you this, being that that's my house, my lease, and, Ms. Kim, you made a mistake. He never, provided any money for me to move in there. My brother did that. With that being said, once I go to the leasing office, she will, because we already meant the leasing agent, the lady, knows
Mhm.
about Ricardo and knows that I never wanted Ricardo there. She will, go ahead and get a trespassing thing for him, because I've been going through this for months. Telling him that he cannot stay with me. Basically, ma'am, he is a very passive aggressive person. I was asleep, we was asleep, right? We
Be
was
careful
asleep.
to talk about the facts, because I'm not going to, this is
Yeah.
not your trial. And all I'm
But,
determining.
I was not aggressive. I was sick. I wasn't aggressive. I had just got through throwing up. I don't know what Ricardo is talking about. I never hit him with anything. You don't see a bottle.
Please, you have a right to remain silent
Yes.
about the facts of the case.
I
You don't
mean,
want to.
I never did nothing, so that's why I'm not afraid to say what I'm saying, because I did not do anything to him. I'm not the aggressor here. I'm 48 years old. I just got a job at Kroger's.
Your
I got
Honor,
hit in my face. I done got hit in
Okay.
my face.
All right,
with a
let your
gun.
attorney speak for you. Let your attorney speak for you.
No, I'm just,
But I'm going to do the $2,800 surety bond that I've already ruled, and no drugs, alcohol, or weapons while on bond. And the stay away if it is determined that he does not reside there, then you can reside there. So that's to stay away with conditions, and then no further contact with Mr. Bray. That's all out order for now.
Thank you very much, Your Honor.
All right, thank you.
Position 1, Mr. Hernandez, Astorga.
Judge, that's my
I
case.
see, right, I see the interpreter here. Which case do we have the interpreter for?
That's
Good afternoon, Your Honor.
Good afternoon.
Good afternoon.
Which case are you here for, Madam Interpreter?
I was told I was here for Mr. Julio Astorga Hernandez.
This case, the first case?
Yes, ma'am.
Okay. That's correct. PD Armstrong?
Yes, Judge.
And what is the language?
Spanish.
Spanish? Okay. Madam Interpreter, I will swear you in. Raise your right hand for me. Do you affirm that you will interpret the proceedings from Spanish to English and English to Spanish to the best of your abilities and without any embellishment?
I do, Your Honor.
All right, thank you.
Judge, to clarify, I have not yet had the opportunity to speak with Julio, so if I can be put in a breaker, to do so at the court's pleasure.
Oh, well, we need to do that. What do you have I'm trying to make sure we don't call any of your other cases while you're in the breakout.
Sure.
I should have asked for that at the beginning, but usually they'll tell me when you all come on if you need it, so we can be doing that while we do the other cases. So
I apologize for that.
Tell me at the beginning, huh?
I apologize for that omission.
Okay, no worries.
I have Brooks.
Are they gonna put them in a different room? Because if you can go out the breakout room too, if courtroom 2, we got other clients in that courtroom.
Yes, he will be going to courtroom 3
Okay,
for a breakout.
okay. Thank you, Deputy.
Thank you, everyone.
Señor, lo van a pasar a otra sala para que pueda hablar con su abogada. Momentico.
We can go to position 7, Mr. Hall.
Okay. This is 23 CR 001354J. Jernardio Hall, charged with 1 count of theft by taking. The offense date is September the 7th, 2022. Pre-trial.
He got 8 arrests, mostly driving. I didn't see any theft. That's it.
All right. State.
Yes, Your Honor. So officers were dispatched to 1140 South River Industrial Boulevard, Southeast Atlanta, Georgia, responding to a larceny call. Upon arrival, officers spoke with the manager, Mr. Arnold James, common spelling, who advised after receiving reports of threat of theft, he began to review camera footage and noticed that on September the 14th at 4:45 a.m., the defendant was captured taking what Mr. James believes to be a computer. Upon taking the computer, the defendant was seen in the same footage taking the computer with the box to his vehicle. Your Honor, the defendant fled the scene. So we have a flight risk concern here. And in fact, the owner tried to reach out to the defendant to just have him to simply bring the merchandise back, but the defendant never returned. Therefore, we are asking that the bond remain the same at $3,500 surety. We're asking for a stay away from the 1140 South River Industrial Boulevard, and no drugs, alcohol, or weapons.
Okay. And this, PD Kim?
Yes, Your Honor.
Okay.
Mr. Hall is 31 years old, Your Honor. He's married with 2 children who are 11 and 17. He's a father. He has been working at Chairman Food as a warehouse supervisor for the last 8 months. Your Honor, he successfully graduated from high school, and he has a special medical condition right now with the diabetes and high blood pressure. It is very crucial for him to take his medicine. Your Honor, my client denies the allegation. He does not know anything about Xbox gaming, whatever that the warrant is accusing of him to steal. He did not steal, and he does not understand why he had to be that way. We have not had a chance to watch the video footage to clarify what he was doing. So we would like to request for signature on bond. This is not a violent offenses, and usually anything that is related to theft has been granted for signature on bond. Thank you.
Okay. And we don't have the victim on the line, do we? Arnold, what was the victim's last name?
James.
Yep, James.
James.
Yes, Your Honor.
Mr. Arnold James? Don't think so. Okay. Anything else from the state?
Nothing else, Your Honor.
All right. I'm going to order a surety bond in the amount of $3,500. I'm going to order a stay away from Arnold James, or no further contact with Arnold James, and a stay away from 1140 South River Industrial Boulevard, and no drugs, alcohol, or weapons while on bond. And I think that'll do it. Anything else, counsel?
He's the sole provider for the family. His wife does not work. So are we doing surety bond really?
Well, I'm looking a little bit at the history. I know we had 8 arrests, and I think pretrial said they were mostly driving. Was that correct? Is that what the state has?
We do have that. However, in 2004, there was a possession of marijuana distribution, but we're going to ask that you keep the ruling that was given earlier with the surety bond of $3,500.
And I believe you stated that Mr. Hall was working. Is that correct?
Correct, Your Honor. He's the only one who's working for his family, and there was no theft history, Your Honor.
Right. I wish we had, or they rather had recovered the computer, the laptop, and I understand they did not recover the item. Is that correct per the report?
That is correct, Your Honor.
So I will stick to my ruling of 3,500 surety bond and a stay away from that incident location, as well as no further contact with the victim, Arnold James, and no drugs, alcohol, or weapons while on bond. All right, that'll conclude this case.
Thank you, Your Honor.
Position 10, Mr. Simmons.
This is 23 CR 001362G. Terence Simmons, charged with 1 count of discharge of a firearm on or near a public highway or street, and a 2nd count of reckless conduct, both with the offense date of March the 7th, 2023. Pretrial.
One moment.
I have it as well, pretrial, if you need my help.
No, I got it. 14 total. Last
Okay.
verse, 2021, failure to appear. For trespass, possession of a knife during the commission. 2021, burglary first degree. Possession of a knife or a firearm during the commission. 2021, trespass, possession of a knife or a firearm. 2018, probation violation. Had an entering auto and obstruction. That was from 2018.
Okay.
2016, marijuana possession, ag assault. Ag assault was indicted. What else? Yeah, that's it.
Okay. All right. ASG Duncan.
Okay, to add to that, I saw a 2015 ag assault that was dismissed and a 2018 ag assault that which the defendant was acquitted, and the 2021 FTA. In this case, Your Honor, it did occur yesterday. The incident location, there are 2 locations. The first one where the defendant was apprehended was 3266 Dogwood Drive, which is the Super A Mart in Hateville. And the second location where the shell casings were recovered is 518 North Avenue in Hateville. In this incident, Your Honor, officers responded to a shots fired call. When Officer Ken Zatter got to that location on Dogwood Drive, he noticed that the defendant had already been apprehended by several other officers and was being detained. Those officers had recovered from the defendant's person a loaded silver and black Glock 43X 9mm with an extended magazine from under his right arm and another loaded magazine from his pocket. The officer indicated that he was able to identify the defendant because he had an ID in his pocket. At that time, he was making multiple outbursts. So the defendant was Mirandized and informed that he was no longer being detained and was formally in custody. He continued to make outbursts after being given Miranda rights without an attorney present. He stated that his friend, Scrappy, his formal name, Brandon Becker, had hit him with a rock, and he responded by shooting his firearm near Mr. Brandon Becker's house, which is at 518 North Avenue. When officers were able to go back to that location, they found the 9mm shell casings in the middle of the intersection of North Avenue and North Fulton Avenue. They put out a bolo for Mr. Becker to try to locate the victim in this case. They were able to locate him, and he did give a statement to police. At this time, we do not have that supplemental report presently. However, the defendant was swabbed for evidence and taken into custody, and the firearms were placed in the proper custody. In this case, Your Honor, the state has some concerns about the risk of reoffense here, given that the defendant is a repeat offender with 14 cycles. A lot of those cycles are aggravated and violent in nature. At least 2 of those arrests did involve firearms accusations. We believe that this defendant is a danger to the community, specifically because when looking at that address, 518 North Avenue, that is a residential area with homes on all sides of that intersection. So we believe that this defendant is an extreme danger to the community, shooting a firearm in response to being hit with a rock in that area. Furthermore, we believe he's a particular danger to this specific victim because he was shooting the firearm in his presence as a response to being hit with a rock. We have some concerns about this defendant's flight risk, given that he has 3 FTA arrests since 2011 and the last being in 2021. We do also have concern that he does not have a positive likelihood to respond to legal processes in a positive way, as he's continued to offend with aggravated assault arrests, property firearm carrying during burglaries, and offenses of those natures, Your Honor. And as you know, the state has a particular concern about the rise in gun violence in our jurisdiction. And it's the state's position that in these cases where firearms are involved, we're going to be requesting, in this case particularly, a $15,000 total surety. That's $5,000 surety on the discharge of a firearm on a public street and $10,000 surety on the reckless conduct. Given this defendant's history with firearms, we believe it's more than reasonable, and given the extreme danger associated with firing a firearm in a residential area, we believe it's more than reasonable. We'd ask for no further contact with this victim. We attempted to make contact and we were not able to make contact. So out of an abundance of caution, given that this just occurred yesterday, we'd ask for that no further contact. Stay away from both of those locations. The Super 8 Mart and the North Avenue address have no alcohol, drugs, weapons, and specifically no firearms. 1 day anger awareness, no alcohol, drugs, and weapons. And 1 day anger awareness, no alcohol, drugs, and weapons, no further violations of Georgia law. And I would like to note for the court that this defendant's burglary is up for order of dismissal simply because the officer was not able to appear for the grand jury hearing at that time. However, that offense did involve possession of a firearm as well. So for these reasons, Your Honor, we think our $15,000 surety is more than reasonable. This case is currently set at $2,000, and given the nature and circumstances, we believe that $15,000 is more appropriate for these circumstances. Nothing further.
All right. PD Kim?
Yes, Your Honor. Mr. Simmons is 34 years old. He was born and raised here in Georgia. He resides with his mother, and he is single. He's self-employed, and his highest education was up to 12th grade, and he has not completed GED. Your Honor, my client has a very limited financial means at this point, so he's qualified for public defender services. So our team will continuously represent him for these cases. My client claims for self-defense. The aggressor, whose nickname is Scarby, he's about 30 years old, male, white, and he was attacking my client to the point that he felt like his life was threatened. That's why he reacted with gun, which he has a license. Your Honor, we would like to request for just $2,000 just to remain as is instead of raising the money amount. He had a failure to appear only because he was incarcerated at the time, so he could not come to the court. That was the reason why he had a failure to appear. So he is surely coming for this case. We would like to request for $2,000 surety bond to remain set. Thank you.
And I'd just like to add that maybe that he was incarcerated on that burglary in the first degree and the possession of a firearm charge, because he was incarcerated for a long time for that. However, Your Honor, the documents clearly indicate that this defendant was Mirandized and told that he was in custody, and he admitted to officers that the victim in this case, Mr. Becker, hit him with a rock, so he shot his gun. Those are the facts that the officers have recorded for the court to recognize in this situation. We understand the defense's contentions. However, being hit with a rock, we don't feel like shooting a gun is an appropriate response to that. And given the danger that it presents, we think our $15,000 surety request is more than reasonable.
Okay. I'm going to order a $10,000 surety bond, and that breakdown will be $9,000 on the firearm and $1,000 on the reckless conduct, for a total of 10. For that surety bond, a stay away from the incident location, which is a supermarket something. I didn't write down the exact name.
There are 2 incident locations, Your Honor. He was apprehended at the Super A Mart, which is 3266 Dogwood Drive. And the shootings occurred at or around 518 North Avenue.
Okay, so we'll put both of those in there, Ms. Bridgewater.
Mhm.
And no further contact with the victim.
Repeat that victim's name again.
His name is Brandon Becker, also known, I believe, as Scrappy.
You say Brandon Baker?
Becker, Becker. My apologies.
All right, got it. No problem.
Mr. Simmons, do you have a question about the bond? Please feel free to call me. I want you to.
Ma'am. That man, he took my ID and my phone and left me on the rooftop and took it. The police know about it.
Mr. Simmons, I don't want you to accidentally hurt your case.
No. There's no hurt when they just flipped us this way. When I was staying in his residence, and when I was leaving, he hit me with the rock in front of people that gave a statement of what.
Please.
He had my ID.
You have a right to remain silent. I strongly recommend you to stay silent.
You need to remain silent, Mr. Simmons, because you may say things and you
I
are
couldn't
saying
help
things.
help, man.
Hold on. We're not here to have a trial. We're not
You
here
raising my bond so I can't get out.
Well,
I didn't do that. He distorted me and then hit me. And you, what are you saying? He had my phone and my ID. How am I supposed to leave the scene?
Well, you have to wait till the police get there.
How am I supposed to call the police?
Mr. Simmons.
Right. You'll have to argue those with your attorney.
Why would you raise my bond?
You will have another day to argue for your innocence.
But why would she raise my bond and put me in a crisis situation when I was in a self-defense situation? I was leaving and he took upon to hit me, and he had my personal items that he threw in the middle of the street after everything happened.
And the state's recommendation was to raise the bond from $2,000 to $15,000. Was that correct?
That was the state's recommendation, because he said he was hit with a rock, so he shot his gun.
So I didn't hear you, Ms. Duncan, the last part.
I was saying, because as we stated already on the record, he said that he was hit with a rock, so he shot his gun. And as he just stated, he was hit with a rock. So that was the state's recommendation. However, I don't believe Your Honor was done ruling on the matter.
I'm sorry, but he was throwing my stuff all in the street, throwing stuff at me in front of people.
Well, I understand, and those are the facts that you will have to argue at your hearing.
I raised my bond
at your trial. Well, I don't know that for sure. I ain't
got no friendliness. Y'all treat me like a criminal, and I was leaving this situation like a natural person.
But we have a firearm discharge.
But if somebody got,
That's very
what would you
serious.
say, would you say if somebody got your ID and your phone and they left you on the rooftop and took the ladder down and the police know about it?
The last thing that I'm going to say, and I believe that you obviously should be quiet and defer to your attorney, and that is, I still would not discharge my firearm in public to put other people's lives in danger. So
No,
we
I
have to
thought he
make
came
sure-
outside when he throwing the stuff out there, yeah, when he got it
I'm
going.
not going to discuss the facts with you anymore. It's a $10,000 surety
Yeah, he could
bond,
have came outside and just smoked me.
and there's a stay away from that incident the two locations that Ms. Duncan read, and no further contact with the victim. I believe that is, no drugs, alcohol, or weapons. I didn't say that.
And
So
can we
that is
add
it.
a specification for no firearms?
Oh, yes, and no firearms, handguns, or any weapons. And if he does have any, he needs to surrender them to law enforcement immediately if he has any others.
Thank you, Judge.
All right,
Thanks,
thank you.
Your Honor.
Can we go back to the interpreter?
Are we ready for I see the interpreters back. Okay,
Yes, position 1.
okay. And there's Ms. Armstrong.
Thank you.
All right, this is 23 CR 001355Y. It is, looks like that's Julio Astorga Hernandez, charged with 1 count of simple battery, family violence. The offense date is March the 4th, 2023.
Estamos llamando a conocer el caso número 23 CR 001355Y, Julio Astorga Hernández, con una acusación de violencia intrafamiliar simple. La fecha del accidente fue el 4 de marzo de 2023.
Pre-trial,
Servicios previos al juicio, puede dar su informe.
First arrest,
I'm
Es su
sorry,
primer arresto.
first,
first.
Su primer arresto.
All right, state.
Muy bien, ¿qué dice el Estado?
Yeah, in this case, the facts in this case is that the victim in this case is Claudia Perez Cabello, if I'm pronouncing that right. The spelling for the last name is PEREZ-CARBAJAL. And when appropriate, we would ask the court to sound for the victim.
Okay.
Bueno, según el Estado, la presunta víctima en este caso es la señora Claudia Pérez Carvajal. Se deletrea PEREZ-C de casa ARBAJAGL. Si puede hacer un anuncio para ver si la víctima está presente hoy.
This incident occurred at 3651 Avansong Village Circle in Milton, Georgia, but the officer made contact. I'm sorry.
Say that address again.
3651 Avansong, spelling AVENSONG, Village Circle, Milton, Georgia.
El incidente ocurrió en el 3651 de la Avansong Village Circle, Milton, Georgia, 30004.
All right.
¿Puedo decir algo?
May I say something?
No,
En este momento no, señor. Espere.
not at this time.
No por el momento.
The officers made contact with the victim at a nearby hotel, who advised that there had been an altercation over dinner with Mr. Astorga Hernandez.
Los agentes tuvieron contacto con la presunta víctima en un hotel que quedaba cerca sobre un altercado que ocurrió durante la cena. I'm sorry if the interpreter may ask for a repetition regarding an altercation that took place during dinner.
It was over dinner.
Okay.
Yeah.
Un altercado durante la cena.
The defendant became upset and threw the food on the floor, and Ms. Perez Carvalho went to pick it up. He pushed her and told her to get out of the home.
El señor acusado se molestó y aventó la comida sobre el piso. La señora Pérez Carvajal fue a recogerla. El señor acusado la empujó y le dijo a ella que se saliera de la casa.
She told officers that she did not want to prosecute and that she only wanted to document the incident.
Ella le dijo a los agentes de policía que no quería llevarle al enjuiciamiento, solamente quería que hubiera documentación de lo sucedido.
However, when officers spoke with the defendant, he stated that he did, in fact, push her with 2 fingers.
Sin embargo, cuando los agentes hablaron con el señor acusado, él afirmó que efectivamente la había empujado con 2 dedos.
However, the juvenile son told officers that the defendant, in fact, pushed Ms. Perez with 2 hands.
Sin embargo, el hijo menor de edad afirmó que efectivamente el señor acusado había empujado a la presunta víctima con ambas manos.
The state has some concerns regarding the defendant possibly being a flight risk.
El Estado tiene inquietudes que posiblemente el acusado presenta riesgo de fuga.
As the victim advised officers that the defendant has only been in the United States for about 4 years.
Como la víctima informó a los oficiales que el acusado solamente lleva 4 años aquí en el país.
So the state's bond recommendation is a $3,000 surety bond.
Entonces, el Estado está recomendando una fianza de caución de $3,000,
No contact with the victim.
que no tenga ningún contacto con la víctima como una condición de la fianza,
Stay away from the address.
que no vaya más a la dirección mencionada,
No alcohol, drugs, or weapons while on bond, and 1-day anger awareness.
nada de consumo de alcohol ni droga mientras está en libertad bajo fianza, ni posesión o tenencia de armas, y un clase de control de temperamento.
And the state would ask the court to sound for the victim when appropriate.
Y el Estado está pidiendo que usted, señora juez, llame para ver si la víctima esté presente cuando sea apropiado.
All right, is Miss Claudia Perez Cardal, I'm not sure if I'm pronouncing the last name correct, or anyone associated with the case with Mr. Astorga Hernandez on the Zoom call?
Señora Claudia Pérez Carvajal, ¿está usted presente o alguien más que está asociado con el caso del señor Julio Astorga? ¿Está presente por medio de Zoom?
All right, sounds like she's not on the line. Go ahead, PD Armstrong.
Thank
Al
you,
parecer
Judge.
no está conectada ella.
Thank you, Madam Interpreter. Mr. Hernandez and the complaining witness have been married for 20 years.
Gracias, su señoría. Soy la licenciada Armstrong, defensora pública. El señor Astorga y la presunta víctima llevan 20 años de casados.
There is no indication that there were any alleged incidents of violence between my client and the complaining witness.
No existe indicación que había incidentes anteriores de violencia entre mi cliente y la presunta víctima.
From what's been presented to Your Honor today, this was a one-off moment in their marriage.
De lo que se ha presentado ante usted, su señoría, aquí hoy, parece que eso fue un evento aleatorio que sucedió en su matrimonio.
That plus the complete lack of my client's criminal history because he does not have one.
Eso, tomando en consideración también la falta en absoluto de antecedentes penales de mi cliente.
I am asking Your Honor to set a signature bond either through the jail or through pretrial.
Estoy pidiendo a su señoría que usted le imponga una fianza bajo palabra a través del Departamento de Servicios Previos al Juicio o a través de la cárcel.
Of equal importance,
De igual importancia,
I am asking Your Honor not to impose a stay away provision
estoy pidiendo que usted no le imponga la condición de ningún contacto
or a no contact provision
o una condición de que no vaya más al domicilio indicado,
because this is my client's home
porque es la casa de mi cliente
and there have been no reports of any previous violent contact.
y no se ha reportado ningún contacto violento anterior de ahí.
My client has a very well-paying job.
Mi cliente tiene un trabajo bien remunerado.
He has maintained that job for 20 years.
Ha mantenido ese trabajo durante 20 años.
2 teenage children live in the house with him and his wife.
2 hijos adolescentes que viven en la casa con él y con su señora.
And he is, strike that. We submit with what has been presented to the judge. Thank you.
Y la defensa dice presentado con la información presentada ahora.
Your Honor, briefly, if I may.
Okay.
According to the report, the victim told officers that while the defendant is normally verbally abusive, he has physically put his hands on her before while living in Mexico.
Si me permite su señoría, si puedo decir algo brevemente. Según el informe, la víctima informó a la policía que como el señor detenido usualmente se comporta de una manera abusiva verbalmente, físicamente la ha tocado de una manera ofensiva mientras estaban en México.
So the state would ask Your Honor to issue the stay away, no contact orders.
Entonces, estamos pidiendo de parte del Estado que le emiten la condición de no regresar más al domicilio y tampoco que no tenga contacto con la víctima.
Well, I do have some concerns about the allegations regarding the incident.
Sí, tengo inquietudes sobre las alegaciones de este incidente.
However, I want to make sure that the victim will be safe.
Sin embargo, quiero asegurar la seguridad de la víctima.
And I want to make sure that there's been an ample cooling down period.
Y quiero asegurar que ha habido suficiente tiempo de por medio para que las cosas se calmaran.
And because of that, I believe that the parties need to be apart for that cooling down period to happen.
Por eso yo creo que sería prudente que las partes estén separados durante ese plazo para que la situación se tranquilice.
So I'm going to order a $4,000 signature bond.
Entonces le voy a imponer una fianza bajo palabra de $4,000.
And that signature bond will be through the jail.
Será una fianza bajo palabra a través de la cárcel.
And I'm going to order 1-day anger awareness course.
Y una clase de un solo día para el control de temperamento.
I'm going to order no further contact with Claudia Perez Cardial.
También ordeno que no tenga más contacto con Claudia Pérez Carvajal.
And a stay away from 3651 Avansong Village Circle in Milton.
Que no vaya más a 3651 de la Avansong Village Way en Milton.
No drugs, alcohol, or weapons while on bond.
Nada de drogas, alcohol, ni tenencia de armas mientras está en libertad bajo fianza.
And that's the ruling of the court.
Y eso sería mi fallo.
Oh, I don't know. Does Mr. Astorga Hernandez need a one-time escort to return to retrieve any personal items?
No sé, señora Astorga Hernández, ¿necesita usted que la acompañan una sola vez al domicilio para que usted recoja sus pertenencias?
Judge, we would ask for one. Thank you for bringing that up.
Okay.
Se lo pedimos, sí, su señoría, gracias por mencionar esto.
All right. Anything else, counsel?
¿Algo más, licenciada?
No, Judge, thank you.
All right.
No, su señoría, gracias.
All right. Thank you. That concludes this case.
Gracias. Está concluido este caso.
All
Thank
right.
you, Your Honor. May I be excused?
Yes, you may. Thank you, Madam Interpreter. Appreciate it.
Have a great day.
You too. Thank you.
Position number 12, Walker.
This is 23 CR 001363F. Antonio Walker. Battery family violence is the charge. The offense date is February the 18th, 2023.
Ready?
Oh, I'm sorry, pretrial. Yes.
15 total. Last arrest was September. Failed to appear out of Rabin County. Before that was another September. Theft by conversion. That's open in Fulton. 22 CP 212018. Got an open battery DV in state court. 22 CR 003 509G. An open DUI in Rabin County. That came from an April arrest. 2021 fugitive from justice arrest out of Alabama. 2020 suspended license. 2019 FTAs for suspended license. DUI conviction. 2017. That's it. He got something out of state. What state is this? This is Kansas. 2016. It says taxation, no drug, stamp, marijuana. I don't know, some drug crap. That's it.
Okay. All right, state.
Your Honor, in that open state court case 22 CR 003509G, that case is in open bench warrant status. That case is against this same victim, where the defendant received a $3,500 good bond on June 4th, 2022, and was told to have no further contact with the victim in today's case by Judge Law, which he has clearly violated given the facts of this case. This incident before the court today occurred on February 18th, 2023 at 2608 Charleston Drive. Officers responded to a domestic dispute call. The victim in this case is Taisha Brooms. That's TYESHIA. Last name Brooms, BROOMES. Ms. Brooms is the wife, present spouse of the defendant in this case. And when the time is appropriate, the state would like for her to be sound for it, even though we were not able to make contact. In this instance, officers arrived and they spoke with Ms. Brooms, and she stated that she was asleep on the couch in her home because her and her husband, the defendant in this case, had been in an argument prior to that, the prior night. And she stated that they were still upset, so she tried to separate herself and sleep on the couch. And she stated that when he came home, he left and then he returned moments later and began fussing and yelling at her. He asked her where was the other phone that she had and told her to give it to him. And then he picked up her phone and she grabbed her phone and she attempted to run upstairs to her father-in-law to avoid any other issues with this defendant and so that he could stop his son. She stated that while they were running up the stairs, he grabbed her by her arm and attempted to take the phone. She stated she screamed out for her father-in-law, who did in fact come out of wherever he was upstairs in the home and tell his son, the defendant in his case, to get off of Miss Brooms. It's indicated that at that time, the defendant told his father, fuck that, and continued to dig his nails into Miss Brooms' wrist, causing visible injuries that the officers notated. He was not on scene when officers arrived. She told officers that she was going to call her mother to come and pick her up. Officers observed those open marks on her wrist. He had left the phone that he attempted to take, that he did eventually take from her, because he squares her wrist to the point where she had to let go of the phone. He left it on the back porch and fled the scene. She stated that at that time she did want to press charges. We were not able to contact her today. However, the state does have a severe concern about the risk of reoffense. Not only does this defendant have 3 open cases, he has a case that is an open bench warrant status with a no further contact order with this exact defendant from less than a year ago that was ordered by Judge Law. We have concerns about intimidation of this particular witness, given that the parties are married and still live together despite that no further contact order. We have concerns about this defendant's flight risks, given that he has an FTA from 2022. And we do not believe that this defendant has a positive likelihood of responding to the legal processes, because he's been told before to have no contact with this particular victim. He's been told to stay away, and the defendant has continuously ignored all of those things, and not only ignored the court's orders to stay away and have no further contact, has continued to batter this particular victim, leaving visible injuries on her person to the point where she needed to call others to try to help her de-escalate the situation. He has other open Superior Court cases involving theft as well. It's for those reasons, Your Honor, given that this is a continued cycle between these parties and the fact that we were not able to make contact with her, given that she had those visible injuries, we're going to be requesting a $7,500 surety. Again, a no further contact with the victim in this case. Stay away from the incident location, which I believe is a different location from the original bond order back in June. It's 2608 Charleston Drive this time. We'd ask that he stay away from there, given that even though this occurred in February, we don't know where this victim is, and if she's residing there, we want to make sure that she's safe. We ask for 2 weeks of anger management, no alcohol, drugs, weapons, and no further violations of Georgia law.
All right. PD Kim?
Yes, Your Honor. Mr. Walker is 35 years old, and he was born and raised here in Georgia. His parents are all here in Georgia. He's not running away. Your Honor, he has a public defender representing him for a 22 CP case, which he believed it was all closed, and yet it was still open today. We found that out. My client and complaining witness, they have been separated for about several months. They are going through a divorce right now, and his wife does not reside at the 2608 Charleston. She's with her mother, and I do not know the address of that mother's place, but she does not reside at incident location. He has 2 children, 6 and 7 years old, both reside with Mr. Walker. And at that time of the incident, they were with mother-in-law, victim's mother-in-law, which means my client's mother. He has been working as a film, audio engineering professional for about 17 years, and he graduated from high school. He does not have any disability or serious health issues. We would like to request for signature on bond, and yet, if Your Honor is not inclined to give him a signature on bond because of the open cases, we would like to request for maximum $1,000 good bond. Thank you.
And the court would like, the state would like the court to sound for Ms. Brooms just in case she is here.
All right. Is it Taisha Brooms? Taisha Brooms. Don't think she's here. All right, I am ready to give my ruling. based on the open case and history and other y'all factors that I am weighing here, I'm going to order the $7,500 surety bond. I'm going to order no further contact whatsoever with Taisha Rooms. I'm going to check all the boxes on the bond order to stay 200 yards away from her, have no contact through social media, third parties, or in any shape, form, or fashion. I'm going to order, and what did the state say? The stay away from the 2608 Charleston?
Yes, Your Honor, that is the incident location, and it's indicated that she was staying there at the time as she was sleeping on the couch because they had an argument the night prior.
Okay, stay away from that location. Also, I am going to order in this case the 2 weeks anger management course and no drugs, alcohol, or weapons while on bond.
And Ms. Kim, would you be able to clarify for the state, are those children between the defendant and this victim?
Yes.
We'd also ask for third-party contact of for the children.
All right, and third-party contact, third-party person to be the, I lost the word I was going to use there, the facilitator of visitation, for lack of a better word, so that they do not violate, or he does not violate, rather, the conditions of the bond for the no further contact. So if visitation is allowed, it must be facilitated by a third party.
Your Honor, 2608 Charleston is my client's place. If she does not reside there, can he return?
I see the defendant raising his hand. Is that what he's going to tell me?
It's indicated that she resides there, and out of abundance of caution for her safety, we are going to ask for that stay away, Your Honor, given that they have multiple instances of battery, family violence. If for some reason that turns out not to be the case, the defense at a later time could ask for a modification, but since we weren't able to speak to her.
She has a CT, Your Honor. I'm sorry, but she said she has a CT at my father's house. That's my father's house. We moved out 4 months ago. I followed you guys' rules. I have a move-in date in my new home in April 3rd. She never supposed to have been there over a year ago. That's my safe haven spot. She doesn't live there. She was not sleeping there. It's public record. She has a seat criminal trespassing at 2608 apartment 11A, my father's address. This was before everything else. I've been keeping my distance. I called the police yesterday, and due to me having a warrant, I had to go in, but I called them and they can tell you that she was intoxicated. I'm pretty sure it's in the report. I've been keeping my distance, Your Honor. I've listened to you, what you guys gave me, and the other open cases was handled. I had a $5,000 lawyer, and I extradited to Rayburn County last time I was here and closed that. That was a part of it.
Mr. Walker, I strongly recommend you to stay silent.
And Your Honor, I'll defer to the court. However, I will indicate that the record does show that his father was with the victim when the police arrived during these incidences, when it was reported to officers what had occurred. So we would defer to the court, but out of an abundance of caution, since we were not able to speak to her, we would be requesting to stay away.
I understand your points, Mr. Walker. But unfortunately, this is not your trial where you would bring proof of all those things. And I do have to err on the side of caution so that this victim will be safe and she will not be put in any danger or harm's way at this point. So your attorney can apply and make a motion rather to the court for a bond modification once you have the documentation or a different address that we can confirm once we talk to the victim that she's going to be in a safe location, since you all keep having these incidences.
Your Honor, the CT was because she busted my lip. I mean, that's why she got the CT. I didn't, when the CT was to protect me. And she's coming over there constantly.
If she does, then you can call the police, I guess.
I called them yesterday.
Well, that didn't work too well, I guess, did it? So at this point, I'm just going to have to go with you staying away from this location. I know it may be your father's location. If you live somewhere else, then you shouldn't have a problem not going there. If your father wants to see you, he needs to come to your place.
No,
Or y'all talk on the phone.
I was staying with my father to April 4th. Well, one last question, Your Honor. Is it any possibility for you to reduce it any bit? Because I have to move in on the 4th into my new home. And it's 3 times the rent, as you know, in Atlanta now. And it's quite a bit.
Well, I understand, but we have some serious allegations here of a victim that is continuing to be battered. And she does not have to take that or be subjected to that. And you were already under a stay away. And now we have a new case.
I understand.
You should do
I was
open
staying away,
case.
Your Honor, because the address was 3152 that I was supposed to stay away from, Your Honor, and I was. I've been at my father's house since. I haven't been at her location. I never had to stay away from my father's house. That was my safe haven.
So he's saying he never had to stay away from the
No.
Charleston Drive.
He did not. If I may, the state made it clear that he has not had to stay away from this location. It occurred at a different location. That 3152 was the previous stay away given by Judge Long. However, this incident occurred. She was there. She stated that they had been arguing the day prior and that the police were called and he fled the scene after attacking her about a phone. So given that we were not able to talk to her, our recommendation again for the court would be a stay away. However, we would defer to the court.
I guess my only thought is if he doesn't live there and she doesn't, and it's his father's home.
I do live there, Your Honor. I do.
But you're supposed to be moving.
No,
So let's just go with the stay away to move it along. So I have other cases. I'm going to go with the stay away because presently you do. And I don't want you going there to run into her or her going there running into you. So right now, for the safety of everyone, and to make sure that there will be no more incidences like what we have here, you do have an open case as well. I'm going to order that stay away. All right. Thank you.
Thank you, Judge.
Thank you, Your Honor.
Okay.
Position 2.
This is John Bunton.
Yeah, ma'am. Yeah, ma'am.
Okay, sorry if I'm mispronouncing your name. It's case number 23CR001356B, charged with 1 count of criminal trespass, 2nd count of simple battery. The offense date is March the 7th, 2023. Pre-trial?
24, 26 total.
Okay.
He was arrested in 2018 by ICE, deportable alien. Crimes involving moral turpitude. Not really sure what that was. 2016 arrest by ICE. It was a burglary. Let's see. December 2022, he was arrested on murder, simple assault, trespass, disorderly conduct. November 2022, shoplifting, city of Decatur. November 2021, disorderly conduct, terroristic threats. 2020, DeKalb County, terroristic threats, 2 counts, conviction. 2020, shoplifting. Got another shoplifting. That was a conviction from 2020. 2019 shoplifting, it just says bind over. Another 2019 shoplifting, bind over. I got disorderly conduct, 3 counts. Interference with government property, those were convictions. 2019 out of DeKalb. Shoplifting conviction, 2019 DeKalb. Another 2019 shoplifting arrest, 2019 trespass, NOLO. 2018 disorderly conduct, pled NOLO. 2018 shoplifting, 2018 failure to appear for terroristic threats. Let me know when you heard enough now. 2016.
I have heard enough.
All right.
Thank you. All right, State.
Yes, Your Honor. The facts in this case is that on March 7th, 2023, the defendant, Mr. Bunton, entered the Midtown MARTA station without the owner's effective consent in violation of his current suspension that was issued on October 21st, 2022, and went into effect January 10th of 2023, where the defendant was to stay away until March 11th of 2023. The victim in this case regarding the battery is Brianna Carter. The first name is spelled Beranna. We asked the court to sound for the victim when appropriate. While at this location on this day, the defendant ran up to Miss Carter and struck her from behind in the face with a closed fist, according to the report. The state does have some concerns with the defendant reoffending, as he, based on his criminal history with 24 cycles, it seems that he has an issue maintaining lawful behavior while out on bond. So the state would ask to go with the $3,500 surety bond, stay away from the MARTA Midtown location, no contact with the victim, no alcohol, drugs, or weapon while on bond, and the 1-day anger witness. And again, we ask the court to sound for the victim when appropriate.
What's the breakdown for your recommendation?
It would be $1,000 surety bond for the criminal trespass and $2,500 for the simple battery.
All right. And we have the victim, is it Brianna Carter? Brianna Carter. All right, she's not on Zoom. Go ahead, PB Armstrong.
Thank you, Judge. My client has lived in Atlanta for quite a while. He is employed, and we would just ask that you set the bond that's appropriate in this case. Thank you.
All right. I'm going to order the $3,500 surety bond, $2,500 on simple battery, $1,000 on the criminal trespass. I'm going to order the stay away from MARTA, the Midtown station, and to comply with all the trespassing rules that MARTA has already put into effect. No further contact with the victim, Brianna Carter, and no drugs, alcohol, or weapons while on bond. I'm not going to order anything else at this time. All right, anything else, counsel?
No, Judge, thank you.
Position 3, Brooks.
(23 CR 001357Y), Johnny Brooks, charged with 2 counts of theft by taking. The offense date, one is, I have February the 14th and one February 21st, 2023. I know that the same dates or different dates.
I believe they're different dates, Your Honor.
Okay.
Second arrest, disorderly conduct conviction is all I saw.
All right, State.
Your Honor, this incident occurred at 6850 Peachtree Dunwoody Road in Atlanta. The victim in this case is Matthew McPalmer. McPalmer is spelled McPalmer. We asked the court to sign for the victim when appropriate. The facts in this case is that on February 15, 2023, law enforcement responded to the apartment complex located at that address in reference to a theft report that occurred on February 14th. Mr. McPalmer advised officers that he had received an alert from Amazon that his package was delivered, only to arrive and notice that it had been stolen. A neighbor had a Ring doorbell that showed the defendant, Mr. Brooks, who services the apartment complex as the valet trash person, still in the package. On February 21st, a replacement package was delivered, and the same thing occurred. Mr. Brooks is shown stealing the package on that day as well. While the defendant has limited criminal history, the state is concerned with the defendant reoffending, as he committed the same crime twice to the same victim within about a week or two apart. So the state would ask for the $2,000 surety bond, no further contact with the victim, stay away from the victim's address, no alcohol, drugs, or weapons, and the anti-theft course.
All right. PD Armstrong?
Yes, Judge, thank you. My client has lived in the Atlanta area since about 2017. He did move up here for work. It is the defense's position that there's going to be significant issues with identity, and he is maintaining his innocence. Given his almost total lack of criminal history, except for a DC conviction, we are asking Your Honor to allow my client to enter a bond through a pretrial and complete whatever terms Your Honor deems appropriate, including the theft class. Thank you.
All right. I'm going to order a $3,000 signature bond through a pretrial per judge. I'm going to order stay away from 6850 Peachtree Dunwoody Road. I'm going to order no drugs, alcohol, or weapons while on bond. And I'm going to order no further contact with Mr. McPalmer. And I will order that, is it a one-day theft class? Is that something you all can do pre-trial?
Yeah, I think they got some type of theft on.
Okay.
He was recommended, so you don't have to purchase.
Oh, okay.
Is that 15 on each charge?
Yes, I'm sorry, 1,500 on each. And if there's nothing else, counsel, that's it.
Thank you, Judge.
Mm-hmm.
And I'm sorry, Your Honor, did you order the theft class?
Yes.
Okay.
Position 13, Williams.
This is 23 CR 001364G, Kendrick Williams, charged of 1 count of simple battery, family violence. Offense date is March the 7th, 2023.
I got a first arrest.
Okay. And state, before you go ahead, I have someone in the chat.
Yeah, I believe that's the victim who would like to be sound for at the appropriate time.
Okay. Go ahead, Ms. Duncan.
This incident did occur yesterday at 6050 Roswell Road, apartment 522 in Sandy Springs. Officers responded to that location in reference to a domestic dispute. They made contact with Mr. Kendrick Jackson, that is the victim in this case, who advised officers that his now ex-boyfriend, the defendant in this case, assaulted him by hitting him multiple times. Mr. Jackson told officers that the defendant had asked him to meet him at the pool so that they could have a conversation in relation to in reference to their relationship. And when he arrived to he said that they are no longer dating, and that when he went to the pool, he was assaulted by this defendant. It's indicated that when officers spoke to the defendant, he advised that the victim, Mr. Jackson, was cheating on him, and that he went through his phone and also saw it through his Apple iWatch, and that's what caused the altercation. The defendant did admit to officers at the time that he pushed the victim, Mr. Jackson, in the chest with the phone in his hand. He also admitted to picking up Mr. Jackson, which was another assertion that was made in the warrants. The victim in this case did grab a kitchen knife to defend himself. There is video of the incident. The victim can be seen with a kitchen knife in his hand while walking away and attempting to call officers and talking to the 911 operator. Given the facts and circumstances as alleged, we do have some concern about the risk of offense. This appears to be a breakup situation that has turned violent, and we're concerned that if these conversations or interactions continue, more violence will ensue. We have some concern about intimidation of the witness because this victim did call officers and felt the need to protect himself from further attacks from this defendant by grabbing a kitchen knife. We were not able to make contact, and the person that we did call said that we had the wrong number. However, we do have the victim on the line, so the state would ask that the court sound for that victim when appropriate, but we do have some concerns about intimidation of the particular witness given these cycles of violence. It's for those reasons we understand that the defendant does have a limited criminal history, but given the physical violence alleged between the parties and the circumstances, we'd be requesting a $2,500 surety. No further contact with the victim in this case. Name as stated on record, Jernardio Jackson, that's Deondrik. Jackson, common spelling. It is indicated that both parties lived at that incident location. So we're going to be asking for a stay away, 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. And if the court would like to sound for the victim in this case when appropriate.
All right. And give me the victim's name again.
His name that we have it as Jernardio Jackson. That's Deondrik Jackson, common spelling. And I apologize if I mispronounced it.
All right. Is Jernardio Jackson or anyone affiliated with the case with Kendrick Williams on the Zoom line?
I'm present.
All right. Mr. Jackson, do you wish to address the court today?
Yes, Your Honor.
Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, you put your hand down. What would you like to tell me?
Your Honor, there's no intimidation. This is the first time we've had any type of dispute in this nature. It was provoked on my end. I had been pushing him, antagonizing him for days verbally as well. And yesterday, he only pushed me. It was nothing major. Again, this is the first time we've had this, and I only called law enforcement because I've had a childhood trauma of abuse, and I just panicked and called them. But he's nonviolent to me ever. And I also moved out as well and moved back in with my mother.
Okay. So who resides at this?
Me and him both do.
At the Roswell Road, apartment 552?
Yes, Your Honor.
So you do live with your mother or you don't?
I moved out yesterday and moved back with my mother. Again, we've never had any issues like this, and it was really just a push. I think I overreacted just from some childhood trauma and just called the cops.
All right. Anything else? PD Kim?
Yes, Your Honor. Mr. Williams is 29 years old.
Oh, and hold on 1 second, just making sure, Ms. Duncan, do you have any cross-examination of the witness?
Mr. Jackson, I just want to clarify what you were stating to the court. You're indicating that you moved out of the incident location yesterday after the incident with the defendant?
Correct.
And he did, in fact, push you and pick you up yesterday at the pool when you went to talk to him?
Yeah, only push and pull. He never hit me or anything.
I understand. After he did those things to you, you called the police, correct?
Correct. He had my phone as well, so I called also because I wanted my phone from him.
Okay. And you stated that at that time you were somewhat afraid because you had trauma in this area before, correct?
Yes, from my childhood with my father.
Nothing further.
Okay, go ahead, PB Kim.
Yes, Your Honor. He is from Mississippi. He's been here in Georgia for the last 2 years. He's gainfully employed at Mill Creek Property as a leasing consultant. He also graduated from high school successfully, and he is pursuing his real estate license right now. He's professional, and he has no criminal history whatsoever. He also has 2 minor children, 5 and 9 years old, that he has to support and take care of. Your Honor, we would like to request for signature on bond and no further violent contact, since Mr. Jackson is not afraid of my client, Mr. Williams, and also he does not even reside there. That's what we would like to request for. And there's nobody actually. I also want to ask Mr. Dedrick Jackson to give me some phone numbers so I can give that to Mr. Williams, so that way he can call out if he needs any help. Thank you.
Okay.
Your Honor, given the nature of the offenses alleged and all the circumstances around this incident, we just be requesting that no further contact, as the victim has indicated that he left the incident location yesterday to go back to his mother's home. I'm not sure. Mr. Jackson, do you still have belongings at the 6050 Roswell Road location?
No, I moved everything, but I also don't feel unsafe around him. Again, this is the first time this has happened, so we're definitely able to coexist.
I understand. Given that he doesn't have any belongings there, we defer to the court as far as contact, but our additional recommendation stands, given that he reported to officers and it's on video that at that time he did feel the need to pick up a knife to defend himself from that attack by Mr. Williams. Nothing further from the state.
Okay, I'm going to. I know that this is his first arrest. I am a little concerned as well about the allegations. So what I'm going to do is I'm going to order a $3,500 signature bond through pretrial per judge. $3,500. I'm going to order stay away from 6050 Roswell Road, apartment 552. I'm going to also order no further contact with the victim, DeAndre. What was the last name?
DeAndrick Jackson.
Oh, DeAndrick Jackson.
Yes, DeOndrick. Last name Jackson, common spelling.
Mm-hmm. All right. And so there will be no further contact. Going to order the 1-day anger awareness course and no drugs, alcohol, or weapons while on bond. That should conclude the matter unless council has anything else.
Yes.
Your Honor,
The state would just,
go ahead.
I'm sorry, the state would just like to place its objection to the signature for the family violence on the record.
Okay.
Your
And
Honor,
yes,
I would like to request for a one-time law enforcement officer visit to verify that Mr. Dedrick Jackson is no longer residing there and he returned home.
I moved, so he has no problem coming there. I don't live there anymore.
I hear what you're saying. I'm going to, in the abundance of caution, for your safety, Mr. Jackson, I'm going to have him to come back there first with law enforcement to verify that all your belongings are out and that you don't reside there. And then he can reside there if you don't, okay?
Okay.
For the safety of everyone.
What was that bond?
3,500?
3,500 SOB through the jail. I'm sorry, 3,500 SOB through pretrial per judge.
Yes.
You said anger awareness?
Yes.
Next case.
Position 4, Brown.
Get up.
This is 23 CR 001358B. Ardregas Brown, charged with 1 count of criminal trespass. Offense date 11/25/2020. Pretrial.
14 total, 2018 FTA, 2017 probation, 2014 theft by taking, first offender. That's it.
Okay. State.
Your Honor, this incident occurred at 390 Westlake Avenue in Atlanta, Georgia. The victim in this case is Zira Blake. The spelling for the first name is Z-A-H-U-R-A.
Z-U.
Z-U, my apologies. And the victim is here to speak so this court can sound form when appropriate. The facts are that on 11/25/2020, the victim advised the officer that the defendant came over to drop their son off. When Ms. Blake noticed that the son was bleeding, believing that the defendant had hit their son, she called him out of his name. He became upset and broke a window. The victim wishes to have contact with the defendant. However, the state has some concern as our victim advocate spoke with the victim, who advised the officers that the reason for the dispute was that the son was bleeding from the jaw. The victim determined that the defendant had actually hit the child, and she locked him out of the residence. He broke a window trying to get back in, and glass hit her in the face, causing injury. The officer did not want to, and so the state has some concerns about the intimidation of the victim, since the defendant and the victim shares a child, and they must have, so they'll be inclined to have some type of contact. So the state is concerned about influence. The recommendation is a $3,000 surety bond, no further contact with the victim, stay away from the victim's address, third party contact through the child, and 1-day anger awareness, no alcohol, drugs, or weapons. It's all from the state.
All right. PD Armstrong.
Judge, I'm happy to allow the complaining witness to speak first if your honor is inclined.
Okay. All
Thank
right,
you.
and it's Vahira. What was the last name again?
Blake, B-L-A-K-E, Blake.
Blake. All right. Do you wish to address the court today? I can hear you. Do you wish to address the court today? Maybe I can't hear you.
Apparently they went out, Judge, and I guess they have an audio issue. They're gonna come back on and let me see.
Okay. There it goes.
Hello?
Okay, there you go. Would you like to address the court today?
Yes, I'd like to address the court.
Okay, raise your right hand for me so I can swear you in. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down. Are you in fear of Ardregas Brown?
No, not at all.
Okay. How long have y'all been in a relationship, or what's the relationship?
We weren't in a relationship when this happened. This was 2020. We haven't been dating since 2015. He was dropping my son off and had some reservations about keeping him or whatnot, and said that he wanted to disown him. When he came to the house, his lip was bleeding and he wanted to come inside, and I said, "You can't come inside." And so he kept pounding on the door. And so then he pounded on my window, and I called him out of his name. And that's when he bust the window. As I had my head near the window, he bust the window and the glass hit my face. I do have pictures of the blood and stuff like that. but I didn't press any charges on him. It was the day before Thanksgiving, and the officer let me know that because he didn't stay in the apartment complex, that this would basically be hearsay. So it wouldn't really, it probably would have been denied. So I didn't do anything about it. He didn't see his child for a year. And when he came back around, we were fine. It's water under the bridge. Happened 3 years ago, as I stated.
But you do have a child together.
Yes.
And how old is the child?
He'll be 11 on Friday.
All right. PD Armstrong, any cross-examination, Mr. Young?
No, Judge, as you heard, the victim said that the defendant busted the glass and hit her in the face due to an altercation about her son. So it's nothing further from the state.
All right. PD Armstrong?
Judge, real briefly, has paternity been established?
No, he's not legitimized.
Thank you. That's all I have.
Mm-hmm. All right, PD Armstrong.
Thank you, Judge. As it's obvious, this is an older case. It's from November of 2020. There's been no indication that my client and the complaining witness have had any violent altercations since the allegation that that has been presented today. I am asking Honor to not consider any alleged facts concerning the bleeding, any of the facial injuries, because what is presented to Your Honor today by the state is a criminal trespass charge for breaking the window. So on a criminal trespass charge, I am asking Your Honor to set an appropriate bond, which I do believe is a signature bond given the lack of violent criminal history from my client and the lack of any violent interactions between my client and the complaining witness. And my client is employed in Atlanta. He has 3 children that live with him, and he's newly engaged and just wants to get out so he can keep working and keep doing what he's doing. Thank you.
Okay. All right, I will order the $3,000 surety bond. Going to order stay away from, is it 390 Westlake Drive, I believe. No further contact with Vihuria Blake.
I'm sorry. May I address something? Oh, we don't stay at that address anymore, and he comes and get his son every other weekend. So, as mentioned, this was 3 years ago.
I understand. Making sure that you're going to be safe as the victim in this case, and that there won't be any more incidences. And I do see that. If you're comfortable with no further violent contact, are you comfortable with that? Okay. So I will change that, Ms. Blake, to no further violent contact. I will take off the stay away since neither of you reside there anymore. I'm going to, with a $3,000 surety bond, I'm going to order him to take a 1-day anger awareness course. And no drugs, alcohol, or weapons while on bond. All right, that should be the ruling for this case. Anything else, counsel?
No, Judge, thank you.
All right, thank you.
Thank you, Your Honor.
Position 5, Mr. Copeland.
All right, this is 23 CR 001359C. Aurelius Copeland, you're charged with 1 count of willful obstruction of a law enforcement officer. The offense date is 3/7/2023. Pre-trial.
Yeah, first, SOB jail was a recommendation.
Okay. State.
Your Honor, the incident occurred at 5501 Fulton Industrial Boulevard, Southwest in Atlanta. On this date, a sergeant with the Fulton County Police Department attempted to place the defendant into custody. He refused to give his hands to the officers and tried to get handcuffs. As the officer tried to get handcuffs on him, he continuously shifted his body, hindering the officer. The state would ask for a bond recommendation of $3,000 surety, no alcohol, drugs, or weapon, 1 day disregards to anger awareness. There's nothing further from the state.
All right, PD Armstrong.
Thank you, Judge. Mr. Copeland is 24 years old. He lives at home with his mother and his father, who I believe are present via Zoom. He was leaving a job that he had just gotten, and he was pulled over. We don't know why, because we don't have the benefit of the police report or any of the citations that may or may not have been given to my client that day, but he was pulled over. And what began as a misdemeanor traffic stop for, let's say, maybe reckless driving or maybe speeding or maybe running a red light, ended up with my client on the ground with a gun pointed to his head. We haven't heard that today, but that's what happened. The recommendation is SOB jail. I am asking Your Honor to follow that recommendation from pretrial. And once again, this is an outstanding young man who was treated severely unfairly by the Fulton Police Department. And I strongly encourage him to fight this case. And I hope that my office is there to do it for him. Thank you.
All right. I'm going to order the $3,000 signature bond through the jail. And I'm going to order no drugs, alcohol, or weapons while on bond. And I guess there are no stay away or contact provisions, nothing recommended by the state, correct?
That's correct, Your Honor.
Okay. That's all I order at this time, just a $3,000 signature bond through the jail and no drugs, alcohol, or weapons while on bond.
Thank you, Judge.
All right, thank you.
Yes, announcement on position 6, he waived his appearance.
Okay.
So that's it in courtroom 2.
All right. Have a good one. We'll see you next time.
Thank you, Your Honor. Y'all too.
This is case number 23 CR 001353G. Willie Flagg, charged 1 count of giving false information to law enforcement officer. Oh, 2 counts of that. Offense date is 11/16/2022. Pre-trial.
All right, 39 total. Last arrest was in November, criminal trespass. November probation, 2019 probation, underlying charge burglary with intent. Forgery 4th degree conviction from 2019. 2014 was the burglary. What do we got? Another 2014 burglary probation. Got a given false name from 2013 probation violation. Simple assault, criminal trespass. Can we say peeping Tom?
I'm sorry?
I said, can we say peeping Tom?
I think you can.
That's fine. That was a conviction from 07.
Okay.
He got he got more prior burglaries too. He's a burglar. That's
Burglar. Okay. Thank you. All right. State. Ms.
Yes.
ASG Jones, I'm sorry.
No, it's okay. Yes, Your Honor. So officers were investigating a burglary at 442 Gardner Street, Atlanta, Georgia. That's in Fulton County, when they came upon the defendant, Willie Flagg. However, Mr. Flagg gave officers a name of Derek Flagg and a date of birth that did not match. Upon further investigation, officers watched the body cam, which reviewed that Mr. Willie Flagg gave his brother's name, which is Derek Flagg. We do have a fear of him reoffending. As Your Honor became aware, he did have an incident in November of this past year, plus the 2014 given false information to law enforcement officers, and then his numerous of burglaries, considering that this was a burglary investigation. Therefore, we are asking for a $2,000 surety bond, no alcohol, drugs, or weapons, and no further violation of any Georgia crimes.
Okay. All right, Ms. McLeod.
Yes, Your Honor, my client is 66 years old. So if he has a significant history, he's also old. You know, he's been around the block a little
I'm
bit.
not going to admit to that. That is not old anymore.
I understand. He's older. Let's just say he's older, Your Honor.
Older, right.
Older.
Okay.
What he tells me is that he has already been to court. This incident allegedly happened in November of last year. He tells me he's already been to court and took a plea on this charge. So I'm a little confused because that is what he tells me. He has been in jail for some time also. That's what he tells me, Your Honor.
I see. This is 110 days.
That is correct, Your Honor. And he tells me he's already appeared on this case and that he took a plea. Of course, I have no indication of what the status is. So maybe the state can enlighten us as to what is really going on. Because considering that he's been in jail for 120 days, and this incident allegedly occurred in November of last year, it would be odd for him not to have already appeared at least once.
All right. Do you have anything pre-trial too while the state's looking as well? And
Looking at what?
Nothing.
What are we talking about?
I'm letting the state look on this position, Willie Flagg.
What position is it, Your Honor?
6.
Okay, I'll take a look at it.
Yeah, see what you can find.
This is Katrina. I'm sorry to interrupt, but I do see he had a same incident on November the 16th of 2022, case number 22CR007847G as in girl, that he took a plea on a state all-purpose counter back on December the 8th of 2022 of the charges of loitering, prowling, and criminal trespass. I don't know if those charges were changed at the time, but it has the same incident date of 11/16/22.
Okay. Huh.
It would be my position that if the
Got time served
charges
on it.
arise out of the same incident, that they should have been addressed at the same time. And my client was under the impression that everything in relationship to those particular dates were taken care of when he took the plea.
What say you, ASG Walker?
I say that we can give him a signature bond. I'll be glad to look at it going forward and make sure that this is not 2 different incidents. If it is the same incident, I will submit an all prize, but that's going to take some time. So right now, we just ask for a signature bond and a stay. Well, yeah, a signature bond and a stay away. It could be SOB jail.
Okay. All right. I'm going to give a $3,000 signature bond, SOB jail. Stay away from 442 Gardner Street. No drugs, alcohol, or weapons while on bond. And if the state finds out that it is the same charge, then they will obviously no process.
Thank you.
That's $1,500 on each one?
Yes, $1,500 on each. And I raise it slightly a little just to make sure. Since we're doing SOB jail. And hopefully Mr. Flagg will not give his brother's name or any allegations like that. So that your brother won't be in any trouble.
But Judge, the name of that plea was taken underneath Derek Flagg. So I don't know if that's an alias.
It's taken under Derek. Oh, the brother's name?
I'm assuming, I don't know what his brother's name is. Is it Derek?
I believe his brother's name is Derek, Your Honor. So I don't know why that's the case, but my client tells me he actually went to jail and He actually went to court.
Because those charges were dealt on a state all-purpose counter back on 2022 of December and December the 8th of 2022. And underneath this current booking number that he's in jail underneath now as Willie Flagg is 221-16991. Those charges are associated to his booking screen and shows time served for the loitering and criminal trespass, but given the false information on the officer, it's still open. I think added another charge. I don't know if that was a charge that was missing off of those at the time, and it was just not being accused. But the 11-16-22, it is a given a false name or information on his booking screen, and it looks like the state added another charge instead of one count. It's only, two counts. It's only one count on his booking screen with that date, but it was never dealt with or associated to the other booking, the other CR number that I have given you.
Mm-hmm.
You know, it sounds a bit like double jeopardy to me because my client really believes that this is all over. He is genuinely confused as to what is going on because he thought he had dealt with this issue.
Right. Well,
Right,
but
and
it looks
that's why
like
they
it's
say
two
it's
different
defendant.
charges. Yeah. I'll let
And-
Mr. Walker, he's good at doing his investigations. So he will certainly look into it and he'll send me a no pros today or tomorrow if he finds it out. But it sounds like it might be those false information charges might be in addition to the trespassing, right? Possibly.
Possibly, but we will definitely get to the bottom of it, and we're going to consent to the signature bond. And obviously, if it is from the same circumstances, it would be double jeopardy, so the state would not be able to proceed. I just need to go through Odyssey, look at all the
Right.
paperwork, and make sure it is what we think it is.
Okay. We will do that, hopefully, and we'll take care of it tomorrow if we need to, Ms. McLeod.
Thank you.
And he will find out by then. You can do that by tomorrow, Mr. Walker?
Yes, I can, Your Honor.
Okay, very good.
Thank you.
All right.
Okay, we're ready to go over the calendar.
Yes, ma'am.
Okay, once again, the reset date for the SAP calendar is March the 21st. Position number 1 is reset further notice with a $4,000 SOB through the jail. Position number 2 is going to the SAP calendar with a total $3,500 good bond. Position 3 is reset further notice with a total $3,000 SOB through pretrial per judge. Position number 4 is reset to the SAP calendar with a $3,000 good bond. Position number 5 is reset further notice with a $3,000 SOB through the jail. Position number 6, reset further notice with a total $3,000 SOB through the jail. Position 7 is going to the SAP calendar with a $3,500 good bond. Position 8, reset further notice with a $4,500 SOB through the jail. Position 9, reset further notice with a $3,500 SOB through pretrial per judge. Position 10 is going to the SAP calendar with a $10,000 total good bond. Position 11, SAP calendar with a $2,800 good bond. Position 12 is going to the SAP calendar with a $7,500 good bond. Position 13, reset further notice with a $3,500 SOB through pretrial per judge. Are there any questions, corrections, or otherwise?
Oh, Moon was pretrial. Was I wrong?
Moon,
Yes.
I have Moon is through the jail. Correct me if I'm
Let's
wrong.
see.
Number 8.
I had
Okay.
Moon through the jail
Okay.
as well. Yeah.
Okay.
What was the bond amount for 13?
13 is, let me go to that, $3,500 SOB through pretrial per judge.
Was that anger awareness?
It was
Should be
anger
one day.
awareness.
Mhm.
Yes.
Thank you.
Got
Are there
it. All
any
right. All right.
others?
Great. Nope.
Okay, Judge, this paperwork is on its way to you.
Yes, ma'am. All right.